Well, good afternoon, everyone. Thanks for joining us. My name is Colin McKenzie. I'm a fellow at the Natural Resource Users Law and Policy Center at the University of Arizona, and I have the real privilege of introducing our next two speakers at this year's Mining Law Summit, our ninth annual, again, on the theme of the interface of water and mining, with a particular focus also on the role of what are variously termed impact benefit agreements, community benefit agreements, community development agreements, et cetera. And with that, I just want to give a brief introduction of our two speakers, Kyle Vermette and Ginger Gibson. Dr. Ginger Gibson at the Firelight Group, our neighbors to the north in Canada. And Ginger has a PhD in mining engineering and is a director at the Firelight Group, and along with Kyle, who is a lawyer and is of the Métis Nation. The two of them work on the group's focus, both working with First Nations and local governments to negotiate and also to implement and monitor what they, I think, often refer to as impact benefit agreements in the Canadian context. So with that, on behalf of the Global Mining Law Center at the University of Arizona College of Law, again, it's a real privilege to be able to introduce the two of you, and I'm really excited to hear the presentation, and I know our audience will have so many insights to glean from this and really run with in their lives and in their communities. So thanks so much. I'll turn it over to the two of you.
Thank you so much, Colin, and thank you for the introduction. Firelight is delighted to be presenting to all of you folks today. I will just start by saying a rose by any other name would smell as sweet. So people get fussed in this line of work about the name that you give agreements. But Kyle and I are here today just to demystify these agreements. They're often confidential. So we're here to demystify these agreements and suggest to you that no matter what you call them, it doesn't matter what you call them, because in the end, they're a relationship. They all amount to a relationship that nations, Indigenous governments can hold with companies or with governments. So I'll just say that you did a great job of introducing me. My background is indeed in mining engineering. I'm coming to you today from Treaty 6 territory, which is in northwestern Canada. Edmonton, Alberta is where I'm located. My background is I'm non-Indigenous, so Scottish ancestry, and I'm pleased to be in the territory of in Treaty 6 territory today. So offering some thoughts to you from our experience and Firelight. I'll just let you know that we'll introduce Firelight as soon as Kyle's introduced himself.
Thanks, Ginger. My name is Kyle Vermette. I'm a Métis Nation lawyer and negotiator, more negotiator than lawyer these days, working on negotiating impact benefit agreements, government to government and nation to nation agreements on behalf of Indigenous peoples in Canada. Really excited to be here. A real honor to be able to speak at this summit. So maybe we can start with the first slide about who Firelight is. Firelight is an Indigenous-owned and Indigenous-led consulting firm. So we work for Indigenous peoples and Indigenous peoples only. We provide community-based research to support Indigenous rights, interests, and values. And ultimately, the purpose of Firelight is to elevate the existing expertise that's within nations. That's our job. We're not the experts. Indigenous peoples, their own nation, they have a lot of expertise in their own nation. We're just there to support and bring that expertise to the fore and to move things forward in an effective way. Maybe I'll pass it over to you, Ginger, to talk a little bit more about some of the areas that we work in.
I like the way that you said that, Kyle. And indeed, we are trying to elevate the expertise of nations to negotiate for themselves what is in their interests. Oftentimes, it takes quite a bit of research or technical expertise to support them in their self-determination. So Firelight on slide 4 reviews all of the different areas of research we support nations in, whether it be in health, be it in planning, be it in environmental assessment, mapping. So oftentimes people are preparing maps to illustrate the relationship that they have to land so that they can inform a government or inform a proponent about what it is that matters to them. And so Firelight, we were founded in 2009. I'm one of the original founders of Firelight. We have offices across Canada, and we provide research services in the United States as well to Inupiaq and Indigenous people across the United States. We're really well informed and directed by Indigenous peoples. So, and that's who we work for. We don't work for state governments. We don't work for proponents. And we made that choice explicitly when we started, because our intent was, we looked at the space of negotiation and we realized that companies and governments have a lot of people that solely focus on their interests and their rights and their approaches to managing large resource extractive projects or wind power or hydro. And so when we looked at this space, we realized that very few people explicitly turn themselves to the governance and being analysts for Indigenous people around the issues that they care about. And so that's why we really focused our services in that area. We do, as Kyle noted in slide 5, we do spend a lot of our time, Kyle and I spend a lot of our time in community providing support on negotiations. So we released a impact and benefit community toolkit. Actually, it was interesting. We released this back in 2007. We released it again in 2015, and we're going to be releasing it again this year because the art and practice of negotiations constantly changes, and they're always innovating. Communities are always innovating. And so we're re-releasing it. Our work really tries to break open what is often a confidential space. So often these agreements are left between a proponent and between an Indigenous government. And so that space is kind of secretive. And so it often leaves a bit of mystery associated with it. And Kyle and I really attempt to break open that space and help people to understand the art of negotiation, as well as what can be caught and captured in agreements. Kyle, do you want to add anything on kind of the impact agreement negotiation and that space?
Just to say that, thanks for that, Ginger. I really appreciate that. We're really focusing today on impact benefit agreements, but impact benefit agreements are good neighbor agreements or community, these are all tools that are interim in nature. They're filling gaps that if government to government and nation agreements are fully realized, there won't really be a need to have an impact benefit agreement in place. You'll have a framework in that overarching agreement that will address how major projects operate within Indigenous peoples' territories. So I think that it's not to say that it's a short-term fix, because it's not. I don't foresee Indigenous peoples' nation-to-nation agreements being resolved very quickly. These things take time to do things well. But I do think that it's a really important tool to move things forward at the pace of innovation and at the pace of development. And I think that they can really serve as an important avoidance tool to avoid litigation, which is, I think, often where things end up without the opportunity to negotiate.
So when you asked us to speak, you asked us to think about the relationship between negotiations. So these contractual agreements that companies might enter into with either with a municipality, with a nation. But you asked us to also think about the relationship to environmental assessment. So in every country, we're going to have a different set of rules that prescribe the approach to regulatory review. And so bear with us, because in Canada we have our own approach, Kyle and I, and then in the United States, a different set of rules, of course, and legislation applies. But we did in slide 6 put in a slide that really speaks to that space. So what is happening in environmental assessment when you're looking at a major project is you're liberating information about a project. You're studying it, you're looking at it, you're trying to unearth all of the potential relationships between let's say water, Indigenous people, their values, and impacts that might fall to one nation or to one community more so than to another. And so the art of negotiation is understanding the relationship to that process and getting as much information as possible from that process to support negotiations. And thinking about what we're always thinking about is what is captured in public regulatory instruments. So what is held down? So oftentimes what's held down in public regulatory instruments is what can be put into the water, the levels that are acceptable. What might not be held down is a nation's laws or a nation's specific uses and the protections that they might seek in a bilateral agreement, in a negotiation, might be something that's very specific. I'll just give an example, and I'm focusing in on water, of course, because of the focus of your summit. So in northern BC, I've worked with one nation who has their own water law, and it's a public water law that they've made public themselves. So Indigenous government has released their public water law, and the province has their own water legislation and approaches to governance of water. So there you have two different approaches emerging. They have different values that are guiding them, and yet they had to come to an agreement on how to permit a mining project that was already in operation. And so through dialogue and engagement, and then through the public regulatory process, they managed to come to some level of agreement there, but then they held it down specifically in their bilateral agreement with the proponent. So they made more specific covenants that they held down on water through the approach that the proponent would take to reporting and the requirement that they would uphold their water law, which isn't required in public law, right? So there you get a feel for how environmental assessment can interact with a negotiated agreement and how you can use the public process to understand a project as well as you possibly can, and then use it to also inform and build a private bilateral relationship and a private bilateral agreement with a proponent.
And Ginger, I would just add to that I always think about IBAs as being this way of elevating, like legislative, it's basically filling in legislative gaps. So the legislation goes this far. And what we want is the IBA to build on that. And like you said, Ginger, leveraging the information that's required in those regulatory processes to help raise the standard of environmental protection. And in using, I think the ultimate, of course, is having an Indigenous government applying their own laws in their own territory. That's kind of like the pinnacle of kind of the standard. Because of course, when we're talking about, what's the level of veracity required? What's the level of credibility required? Obviously, oftentimes Indigenous peoples will say, we're holding things to the highest standard. So, ultimately, we're using these IBAs as this way of elevating the standard from a regulatory standard, which is legislative, to an even higher standard through a negotiated process.
So we're diving in deep. We went into the deep end thinking about water and how it relates specifically to environmental assessment and to negotiated agreements. But we should step back, Kyle, and even start by defining what an IBA is. So Kyle, why don't you move into slide 8? What is an IBA?
Yeah, so IBAs, as you can see on slide 8, IBAs are a contractual agreement between mining companies or any natural resource extractive company and Indigenous peoples. And ultimately, one of the nice things about IBAs is that they're a critical tool. There's a lot of flexibility. Governments many people would say governments are not the source of innovation. They are very large. They move slowly. It takes time to put things in place through government. Companies have the ability to be quite innovative through these agreements. So it's a really helpful and important tool to move at the pace of business and move at the pace of development, but in a way that complies with the standards that Indigenous peoples set. Ultimately, communities are looking to achieve a fair and lasting benefit. So if benefits are being received by the company through operating a mine in a traditional territory of Indigenous peoples, there should be some benefit going to Indigenous peoples for that undertaking. And ultimately, we not only want to ensure benefits happen, but we also want to minimize or avoid impacts. So it's an important tool that kind of elevates the standard from the regulatory process. And maybe I'll just, over to you, Ginger, over to slide 9, maybe.
Yeah, so the why of IBAs, these really originated in Canada and Australia in the 1980s. So we've got lots of practice of them. In Canada, they're negotiated between Indigenous peoples and companies. They started in mining. They've moved over to hydro. They've moved over to wind. So lots of different focuses. And now we have lots of agreements in Canada between the governments, the federal and state governments, or provincial governments, and between between Indigenous peoples. So, but the why of them is, Kyle really raised the idea that people are using to protect and manage where they couldn't necessarily, maybe areas and spaces that they wanted protected are not getting protected through the approach of the federal or provincial government. And so people have to take matters into their own hand to take care of things they care about. So cultural spaces, spiritual spaces, areas that need direct and local oversight. They're also in place to really make sure that people can achieve benefits. Oftentimes in Canada, in particular, projects would touch down in an area but have very little, especially once we developed the remote mining approach. So once mines became something that we didn't house communities around, but instead we set everybody into industrial camps, operating 24 hours a day, and operating daily with no breaks. Once that model of work was socially accepted, then it became the case that often Indigenous peoples were really shut out of that form and that workforce. So it's also a way of ensuring that employment can touch down locally, that there can be procurement, that there can also be financial participation. Keep in mind that taxation often doesn't get locally distributed. And so while resource rents are flowing outwards and upwards, they may not be flowing back in. And so this is a mechanism to really ensure that there's financial participation in two ways. So financial participation both through untied revenue that's coming back to the nation, so a revenue share from the proponent, as well as funds to implement the agreements and the arrangements. So that was really important to Indigenous governments, that they actually start to participate financially. These are also mechanisms to set up a really clear relationship. So who speaks to whom, how long are they in contract for? What is that relationship going to look like? So we're really setting up that clarity of relationship so that the proponent has certainty about how and when they're required to be communicating and spending time in the region. And as I mentioned, it's also an approach to really ensure that there's funding for the agreement to be implemented. So not just funds for financial participation, revenue sharing, and funds to the nation or to the organization more broadly, but also so that there's funding for them to implement the agreement.
Yeah, thanks, Ginger. And the only thing I would add to that is that that relationship piece is really key, because what we're trying to do is move from a stakeholder concept to a partner. And I think that's a really important shift that's been happening in Canada. And, it's just a different order of relationship. I think that when you've got, the local cattlemen association has a view on a project, but Indigenous peoples have a different relationship and responsibility to their traditional territory. And so that should be reflected in these agreements. And that's the trend that we're seeing in how these agreements are being structured, particularly with the movement of the UN Declaration on the Rights of Indigenous Peoples in Canada and elsewhere. So I think I'll just mention implications of IBAs, which is slide 10. There are really positive outcomes that can kind of derive from the execution of an IBA. So one thing to remember is that no matter what, the court will always be there. I mean, this is aimed at moving away from a court process, right? It's a negotiated process coming up with something that's feasible for both parties. But of course, courts will always be there. But I think one is trying to put effort into something that might function to avoid that costly and time-consuming and often unsatisfactory process. So IBAs, in our experiences, have been a really important tool in both establishing long-term relationships that are positive but more importantly have utility. So, and they also avoid the cost of litigation, which I think everyone understands often is quite significant, particularly when you compare it to the cost of investing in a good negotiation and a good implementation of a negotiated agreement. But it also allows for these things are iterative and build on each other. So, an IBA for a mine, information that is used for that purpose can be kind of multi-use. So it can feed into land claim agreements. It can feed into, you're kind of constantly building the capacity and information capacity of Indigenous nations to make sure that they're well armed for these important discussions, as I mentioned, that are coming down the pipe in government to government and nation to nation agreements. So we want to be kind of building towards that with each of these agreements. They are project focused, but they can have broader implication as long as they're designed in a thoughtful way. And then ultimately, we're also wanting to align and tell good stories. So we want companies to feel good about what they're doing and look good. We want them to, as long as they're doing projects in the right way and in the right places. And so that's what this partnership is about achieving. So making sure that when companies have ESG reporting, when they have corporate and social responsibility obligations, they want to tell a good story. And coming up with a negotiated agreement that works for everyone is a really important way of telling a good story.
So we're talking a lot about the implications of these agreements in Canada, but of course they're breaking open in the United States and have been for some time. So Kyle and I have watched as our southern neighbors have started to ink what you're calling good neighbor agreements. Of course, these are emerging in the context, and we've just laid out in slide 12 the background for the kind of the good neighbor agreements that are emerging. They're coming into play. So that, with the bipartisan infrastructure law of 2023, you've got the power infrastructure approaches, you've got the requirement for funding that's going to be dealing with roads, bridges that focus on climate change. Infrastructure. And so with this, there's a lot of energy going into these agreements in the United States. So I've seen quite a few talks, quite a few sessions, lots of symposiums emerging on these issues. So there's going to be on slide 13, we refer to the climate infrastructure. So the idea that you're focusing on power infrastructure, roads, bridges, and in these contexts, we'll just note that the DOE is taking a heavy lead in all of these areas. And in fact, in our materials, we've released the DOE map that shows where good neighbor agreements have touched down. We haven't seen, and actually we think it would be really helpful for that map to be looked at from the perspective of who, from Indigenous government perspectives, has actually been engaged in these types of good neighbor agreements. We want to do that research ourselves or push somebody else towards that research because we think it's really fundamental to ensure that Indigenous peoples, who in Canada, these agreements have really settled around Indigenous peoples. That's who's engaging in these agreements. And it's not looking that way in the United States, right? So in the United States, it's very much municipal or a range of stakeholders. And as Kyle said, in Canada, we really intentionally took the language and pulled out the word stakeholder and threw it out about 20 years ago because cattlemen are not the same as Indigenous peoples with inherent rights. And so they can't be on the same plane. They can't be operating and negotiating and discussing matters on the same plane because the interests are just not comparable. And so we think that it would be really helpful in the US for people to really carefully look at those agreements that are emerging. There's some excellent and really interesting practices emerging in the United States around these arrangements, but they need to be. When we were starting to build this space up in Canada, we made lots of mistakes. We started out with not very good agreements, with agreements that 20 years later look incredibly unfair and have caused division. Families have fractured apart. Funds haven't been shared, and companies have come and gone. So, and in the context of agreements that people entered into. So, we urge you to look at the question of who from the Indigenous society in the United States is actually participating in these agreements, and how are they participating. So on slide 14, we really lay out the idea that there's states, counties, and Indigenous peoples that are partnering with the Forest Service and the Bureau of Land Management. They're participating in forest, rangeland, and watershed restoration, and all of this on federal lands. So these arrangements are now coming into play, and we offer you the observation from afar that we've learned a little bit in Canada, and we're still learning.
Yeah, thanks, Ginger. And the only thing I'd add to that is that, as you mentioned, Ginger, the Good Neighbor Authority, which is a legislative entity emerging out of some legislation in the U.S., which allows states, countries, and counties and tribes to partner with the Forest Service and Bureau of Land Management. It's a fairly narrow application of these Good Neighbor agreements, right? It's really limited to forest, rangeland, and watershed restoration. We think that there's much broader opportunity for Good Neighbor agreements or community benefit agreements or impact benefit agreements to take space on other projects. It's a really helpful tool, and as Ginger said, we've kind of made the mistakes already. So I think it'd be quite helpful to take a look at how far we've come, and having that be the spot where the U.S. kind of takes off from.
I would just add that organized labor in the United States has also very carefully touched down on some of these agreements and is making some great strides in protecting vulnerable people in spaces where, in factories and in sites where there's unsafe work. So I think there's a lot we can also learn from back at us about how to approach these matters. I think, when we turn to slide 15, our statement and our philosophy is that these agreements can be incredibly helpful when and if they recognize self-determination. So again, back to that point that Indigenous peoples cannot be put on the same plane as a cattlemen's association or a youth group. They need to be these agreements are in place in Canada to recognize sovereignty and self-determination of Indigenous peoples. We look at economic reconciliation as something that can be offered and advanced in these agreements, specifically when there's training for people to be involved in all aspects of what is on offer for benefits. Kyle, do you want to treat the topic of justice?
Yeah, I think justice is a complex word, and I think that when we think about justice, what we're talking about is how do we account for the past while being able to move forward? And I think what these agreements can do is they're the starting spot. It's the starting place for a positive relationship. And no agreement that I've ever been a part of is a panacea, which means it never resolves every issue. But as long as there's a view to ensuring that each of these agreements are building on each other, they're able to address small aspects of outstanding claims, of concerns of Indigenous peoples, and they build things over time until the federal government or states or provinces kind of are able to address their role and their obligations to Indigenous peoples. So, like I said, it's an interim tool, but it's moving at a pace where Indigenous peoples are seeing tangible results. And I think the final thing I'll mention about justice is that we want to ensure that we're respecting the sovereignty of Indigenous peoples. They in Canada, they have a constitutionally protected and inherent rights. So this is not, they aren't given rights in the Constitution. Their existing rights were acknowledged and recognized and affirmed in the Constitution. So what it does is it's just a different order of authority and obligation. So I think with Indigenous peoples, we want to have agreements that acknowledge that affirm that relationship and that obligation, and that accord with self-determination and sovereignty. These are all things that are really critically important to ensure that Indigenous peoples are well placed and moving things forward as we sign these agreements.
So in slide 16, we just lay out the measures that we've developed. So we're going to talk, Kyle and I are going to talk it, we're going to move into next the kind of what is in agreements. But I just want to note that, every negotiation and each agreement lays out and is only successful when there's a relationship in place that's strong and effective and has clear parameters that lay out, that they're transparent, that the things that have been laid out and the measures that are in them are achievable and they're practical. So, for example, it's really transparent how and who's going to be involved in things. All of the things that are stated in the agreement are actually can be achieved, and they have names associated with them. They have budgets associated with them, and they have timelines and a review process. So in most agreements that we've been involved in, we have a statement about how many people are going to be involved in implementation, how often an agreement is going to be reviewed, and what's going to be done about updating an agreement. So the other part of it is that agreements that don't have a focus on implementation, again, tend to become dated quickly and tend to lose the focus of the parties. So we really have a strong focus on implementation that can be tracked, that can be seen, that has real people in community implementing them and can be reviewed. Firelight ourselves, our organization, is one of our founding principles is that it's relationships that matter. And that's what these agreements should be about, is that they're setting in place strong relationships that keep people accountable to each other, but lay out a firm and clear process that can live over time. And I'll just say that in every jurisdiction where I've negotiated an agreement, the Indigenous people never change. They never move. They never leave that area. That's their land. That's where they hold title. That's where their people are. That's where their families are, and that's where everybody they know comes from. Whereas the company is coming and going. So the reason why it's really important to have strong processes and strong a language associated with accountability is because in some projects you'll see, particularly in mining, you'll see managers flip over 3 or 4 years as their interests vest. And so you need every single person that comes into the company to understand what they have to implement. And so review is required so that they know the intent behind every agreement that's in place, but also accountability for when they transfer the asset from one company to another, or when people flow in and out of that company. So it's hard to hold relationships down with proponents and companies because, as I said, they're constantly changing while the Indigenous peoples are not. Let's turn to what we have in agreements, Kyle.
Yeah, Teen, I think is, I'm just going to talk, maybe I'll start with the first common aspects that we see in agreements. And the first one is legal. And of course, most agreements have kind of the same standard provisions, definitions, and interpretation. These are really important here. For example, defining the area of the project area is huge. It determines what areas where impacts happen. Principles and goals, making sure that they're aligned with self-determination of Indigenous peoples. The UN Declaration on the Rights of Indigenous Peoples in the US, it was adopted in 2011, in Canada in 2016. And I think that what we've been really focused on is how do we implement the the rights that are set out in that declaration. And so what's kind of been emerging lately is consent agreements. So IBAs, but structured in a way that that obtain consent from Indigenous peoples to pursue mining or resource development projects. And that's a different standard than just consultation, which has kind of been the standard in Canada. So, but that's where that implementation that Ginger talked about is so critical, because you can design the best agreement in the world, but if it's not actually happening, it doesn't matter. And you're going to end up where you don't want to end up. You're going to end up in litigation. So one of the things that we spend a lot of time on is making sure that when we're designing these things, we're designing them with thoughtfulness and with intention to make sure that not only is it something that looks good on paper, but it's something that functions in real life. The last thing I'll say is confidentiality, and that's kind of the real sticky part of this whole process. Is that part of the reason why people are not as up to speed on these types of emerging tools is because they're all confidential and you don't have access to them. And one of the things that we benefit from is having been able to be a part of many of the IBAs in Canada. So that's one of the luxuries that we have, is being able to kind of see what the market is on these types of provisions. But maybe, Ginger, I can turn to you to talk a little bit about the financial provisions.
Sure. I'm just going to say that I find confidentiality to be the thing that's got to be kind of thrown out. Confidentiality really protects the interests of the proponent. In holding agreements confidential, they are able to move across the country with greater access to information than the nations or municipalities or whoever they're negotiating with. It allows a great deal of power and control to be held within the hands of the corporation. Very little in the community. So I'm a big fan of Sunshine being a great disinfectant. And I've heard a great call across the United States for these agreements to be made public. I think it really does. It doesn't protect the interests of the parties to keep these agreements confidential, and it makes it very hard for other people to learn from the experience of others. So just a note on confidentiality, that it doesn't need to be that way. And in Canada, in fact, many of our major agreements that are publicly available. So there's two major projects in Nunavut that have public impact, Inuit impact and benefit agreements, the Mary River Mine and the Meliadine and Whaletail projects. All of those, the agreements with the Inuit are public. So anyone can Google them and find them. And it's really helpful to the practice of negotiations to have these things be public. Now, with respect to finances, I mentioned earlier that there's two aspects to financials. One is the cost of doing business. So when you negotiate a good neighbor agreement or an impact and benefit agreement, you've got to anticipate that if somebody's going to be on the other side of the phone and be implementing an agreement with you, that there will be there will be funds put in place to implement the agreement. So I try to always have, and from a negotiation practice perspective, I always try to have somebody in the negotiation team who's always saying, what's that going to cost? How are we going to implement that? So someone who has an implementation hat that's going to think about how things will get implemented and make sure that there's funding for staff, funding for meetings, funding for whatever it is that needs to happen in order for an agreement to actually have legs. Paper agreements, again, they cause conflict. They cause people to be unhappy. They cause people to feel like nothing is being lived up to. So what's the difference between a paper agreement that causes people to be angry and a good agreement is generally implementation funds. Funding can be anywhere from $100,000 annually to $1 million, depending, and even more depending on the size of a project. So we actually have budgeting work tables in the Impact and Benefit Agreement Toolkit that help people to think through the practice of budgeting for long-term engagement of a financial of an agreement. But then there's financial benefits, and that's a different stream. So what we do in the financial benefit side of things is we talk about revenues, and we talk about fair experience and touchdown of financial benefits in community. There's lots of models. They're all covered in our toolkit, but there's also a lot of really good writing on the financial models that are available out there, that are easily available, and folks are welcome to reach out to us for those references. anywhere from equity participation to revenue sharing to annual payments. So, and myself and my co-author, Kieran O'Farkley, I'm sure all of you wondered how to say his name. There it is, Kieran O'Farkley. Kieran and I have written about what the approaches to fairness are when it comes to negotiating financial arrangements. Kyle, we also have cultural aspects to agreements, right? Do you want to touch on that?
Yeah, and I think this is a perfect example of where IBAs can be kind of innovative and move outside of the regulatory requirements, right? Where there can be cultural elements that can be considered and included in an IBA, cultural practice, cultural considerations, cultural respect for culture, and making sure that every process is respecting and consistent with protocol with each nation is really important. And often, as I mentioned, like legislation and regulations don't often have the flexibility to account for those types of things. So I think the other thing that I'll mention is environmental. Ultimately, Indigenous peoples, as Ginger said, companies are transient, they come and go. Indigenous peoples are there to stay. And so they really care to make sure that the environment is protected and they're able to meet their obligations to their territory. So monitoring is often a really key component to kind of environmental provisions in these agreements. And ultimately, one thing that we're seeing with respect to impact assessment is that Indigenous-led impact assessments are often kind of adjacent to these agreements, where Indigenous peoples are the ones who are performing elements or the entire impact assessment process itself. So Canada, certain provinces and federally have substitution opportunities. So it's a way to, I always feel like the level of satisfaction for Indigenous peoples with a process is relative to their ability to make decisions around that process. So the further the way they are away from a decision-making component in a process, the less happy they will be. So they might not like the outcome if it's Indigenous-led, but they can respect it. And I think that's really what we're trying to do, is to try to bring more credibility and more veracity to these legislative processes. And one of the ways that we're seeing that in Canada is to ensure environmental protection is through Indigenous-led impact assessments.
Thanks, Kyle. I'll just add in a couple of really specific granular details to give you a feel for how things can get really focused. So on culture, people can focus on what they want to eat at a site, and that's cultural, right? So if you think about people being at a work site for 24/7 and not being able to eat anything that comes from the land, that's an aspect of cultural negotiation that we often engage. So we might engage, and it relates to procurement as well. So in one context, in a Northern Diamond mine, it's required that the country food, so Indigenous food that people eat on a day-to-day basis, prepared the way they like it, is available at the work camp. But also from a procurement perspective, it also means that Northern businesses that provide country food are available and are secured, rather than a different firm. Northern businesses are secured to provide that country food. So that's an example of two really specific clauses that can really engage the local economy, so that people are locally providing that food. They're cooking in a way that makes people feel like they're at home-ish, and that they're also that the businesses that they've promoted and developed are also being engaged to provide those foods. So that's just an example. But when it comes to business development, which is our next category, we always dig into this component. We take a good look in negotiations at what the project is, how much of it is going to be set out in contracts, and then we really dig into contract provision, whether it's through set-asides, whether it's through a specific focus on how Indigenous procurement can be engaged. But it's always a really clear focus, so that, in the end, again, Indigenous people are there in the area. Why not engage with them as a labor force if you're going to have a large project? And why not engage and build up their own businesses that are in the area already? With respect to infrastructure, we're often talking about what can be left behind. I'm going to give my favorite example. Actually, this is such a great example that I just came across recently in Western Canada. The Millennium Mine is proposing a project in an area, and rather than have the Millennium Mine build a construction camp that comes and goes, so an industrial camp that's in place for 2 to 3 years, the nation said, I'd like all of that construction camp to become a suburb for the community. So the nation, along with federal authorities, found ways to motivate housing infrastructure into the region. The company will leverage those suburbs in the community for the period of time of construction, but then they'll become a really important set of housing opportunities for local community members in an area where housing security and housing supply is very weak. So that's an excellent example where the public process of environmental assessment tied to a negotiated arrangement was put in play in a way that really changed the way a project is playing out. Kyle, you want to touch on implementation?
Yeah, I think that, thanks, Ginger. I think the difference between a successful or a failed IBA is almost always implementation and review. I think that implementation requires setting useful, realistic, and achievable targets. It's also important to know that oftentimes important information is housed within a nation. So they might have an economic development arm, they might have a housing arm, they might have a child and family services arm, and the negotiators of these agreements need to access the information housed in those internally within the nation to ensure that they're able to kind of make good and informed decisions. The other thing is that these are fit for service agreements. So successful metrics on one project. So if we're talking about employment targets, for example, having 200 members of the nation employed at a mine might make good sense for one nation, but there might not be 200 people who are employable in another nation. So making sure that those metrics of success are fit for purpose is really important, because just because it's a big number doesn't mean that it's the right. We don't want to set ourselves up for failure. And the final thing is on review. We want to be able to refine issues without reopening issues. I mean, there needs to be some level of certainty in these agreements. So making sure that the review process is giving enough time for implementation, but you can refine things that maybe aren't working without having to go back to the table and talk about everything else. So this is a really key component to a functional agreement. And the final thing I'll say is that on an implementation level, all of these elements, legal, financial, environment monitoring, business development, they all work together. So you can't, you might be giving up something in one chapter of the agreement while getting something in another. And that depends on the priorities and focus of each nation. Some nations already have a big war chest that they've developed through lots of economic development projects, and they don't need to take a risk and have take a financial risk and maybe work on the profit model. Maybe they'd rather get something safe and secure, something that they can use money to invest in. So every nation has different priorities and different focuses, making sure that the metrics you're picking for success are fit for purpose, and making sure that Indigenous nations are the ones in the driver's seat deciding what those priorities are is really key to these agreements.
So Kyle and I are working towards a write-a-thon. I keep calling it the write-a-thon. So on slide 18, we inform you that Kyle and I are trying to set aside both the funding, find the funding that we need, but also the time in order to rewrite our impact and benefit agreement toolkit. It has been a resource that's been physically available. So nations across Canada have been downloading, but also ordering hard copies for many years now, but we're reissuing it because there's so much happening. In Canada, we have new impact assessment legislation. And in the United States, we have the benefit of the Good Neighbor agreements. So this is an emerging space that's constantly adjusting and changing, which is why we're always giving it a new look. So just a heads up to keep an eye out for when Kyle and I manage to set ourselves down and get busy busy with the write-a-thon. We just want to thank you. In closing, we really want to thank you. The future of IBAs and the future of negotiated practice rests with you. All of the people who are taking this course and are participating in this summit and listening to our words. So we look to you to advise us about the future of negotiations. We're really eager to hear from you. I'll just note that I'm going to be busy involving myself in a mediation on the day when you're doing the question and answer. So Kyle will be available to answer all of the questions. And I'm really looking forward to hearing what kind of questions people have to ask of us. Kyle, any final words?
No, just to express my sincere appreciation for the opportunity to share some of the work that we've been doing, and looking forward, as you said, Ginger, to hearing some of the questions that practitioners will have, and excited to kind of have the opportunity to learn from all of those who are also attending the summit. So really appreciate the invitation. Thank you so much. I'm on. Nice to see everyone.
Good to see you. We do have a couple questions that came in, and the comment, first comment was, so that approach may work in Canada, but the legal framework and the government-to-government relationship is quite different in the United States. And have you run across these differences in working with U.S. Native nations? And I know you did cover some of that. Do you want to anything further you want to comment on that?
Yeah, I think some of the work that we do is in Alaska, and I think that for example, you're right. The relationship, the nation to nation relationship, is quite different. But that's one of the reasons why this tool is important. In Canada, we're using this tool as kind of an interim step until the nation to nation relationship is resolved. I think that it does make impact benefit agreements kind of a more available and more important tool in the U.S., and that's something that we've seen in our work in the U.S.
A follow-up question to that. In the United States, it is the nation that wants the agreement to be confidential. There's a significant political risk to tribal officials to enter into agreements with mining companies. Have you encountered that issue in Canada or in Alaska, for that matter?
Yeah, I mean, that's part of the reason why they're confidential. I mean, there's lots of risk. I think that, however, I think that there are more opportunities for, transparency is a really helpful tool. It's kind of an undervalued tool a lot of times. And I know that, you want to protect each of the nations want to protect their interests and make sure that they're not, putting information out there, and certainly companies are of the same mind. But at the same time, there are ways to communicate kind of the elements of these agreements without kind of breaching the confidentiality elements or requirements. So I think that one of the reasons why we find that it's the confidentiality, we understand the constraints, of course, and many of the agreements we work on remain confidential. But I think that particularly amongst Indigenous peoples, being able to share successes with each other is really an important element. It's also reforging kind of existing nation to nation diplomatic ties amongst Indigenous peoples. So that's something that we're seeing as something that, yeah, you might not want to post it on the website, but you do want the ability to work with your neighboring communities to kind of elevate everyone on the playing field.
We have a comment here. It says, for your toolkit, this should be a potential funding source, particularly if you could do a traditional toolkit. Have you had any thoughts about that?
Yeah, it's challenging because I think that, for example, like in Canada, there are 634 First Nations. There are at least 5 governing members of the Métis Nation, and there's at least 4 Inuit settlement regions. And so trying to settle on one, traditional approach is challenging. There's lots of differences amongst nations. And so What we've tried to do is just come up with some of the practical elements. But I do hear that, and I think that there is lots of room and important work that nations themselves can do to kind of take some of our general advice and make it more applicable to specific nations' histories and culture.
And another comment or question here is, in your experience, is there scope for more elements of these agreements to be included in legislation?
Yeah, absolutely. I mean, I think that I think it's Article 19 of the UN Declaration on the Rights of Indigenous Peoples that calls for states to get free, prior, and informed consent before enacting legislative measures that might impact Indigenous peoples. And so I think that that type of involvement of Indigenous peoples in the drafting and development of legislation is really important. I think that legislation can be a critical tool. It's one of the main tools that we use in Canada to access and kind of set standards for how we want to kind of work together. So it definitely is a tool. It just is a little bit more of a slow moving tool, and one that as governments change can have more or less impact depending on kind of what's happening. So that's one of the reasons why we feel it's important to empower Indigenous peoples themselves to either develop their own agreements that accord with their own priorities, or to enact their own laws that accord with their own cultural values.